Hello, my name is Dr. Michelle Staggs-Kelsall, and I am the co-director of the Centre for Human Rights Law at SOAS, University of London. What follows is a recording of an event that the Centre held on the 13th of January 2025. The title for the event was Mobilizing Law in Defence of Palestine, the ICC arrest warrants, the Arms Trade Treaty, and the UK's obligation to prevent genocide. We had three speakers join us on the evening: Daniel Makover, who's a partner at Hickman and Rose, Dr. Irene Pietra Paoli, who is a senior researcher at the British Institute for International and Comparative Law, and Dr. Shared Hamouri, who's at Kent University. All the speakers' profiles can be accessed on the blog which accompanies this video on our website at the Centre's email address, at the Centre's web address. Additionally, Dr. Nima Soltani gave comments and in discussion. In terms of why we decided to hold the event, this forms the third in a series of lectures and discussions that we've held under our theme of this year: Imperialism, Colonialism, and Human Rights, the litmus test of Palestine. And I think you'll see in what follows a very clear articulation of why it's necessary to think about the obligation to prevent under Article 1 of the Genocide Convention at this particular moment in time. As was already indicated by the International Court of Justice in the Bosnia v. Serbia case, and further affirmed in the Gambia versus Myanmar case, the obligation to prevent genocide is instigated from the moment at which a state determines that there is sufficient risk, a plausible risk, that genocide will occur. It is not necessary, therefore, to prove that the genocidal acts in question will subsequently amount to genocide. It's sufficient that there is a risk entailed. And as we'll be discussing tonight, this is an obligation erga omnes partes, which means that all member states of the United Nations are obliged to foresee and undertake prevention of the risk of genocide, including, of course, the United Kingdom. The discussion begins with Daniel expressing why he thinks it's important at this moment in history that we think about this in the context of the UK and other third-party states, with a particular focus on how the UK's obligations arise. I hope you enjoy the rest of the discussion.
Well, thank you, first of all, Michelle, and the School of Law, the Centre for Human Rights, for inviting me to speak on this important subject. Well, obviously, what I would hope will happen in many jurisdictions is that there'll be litigation brought by those who have standing, NGOs, individual victims, to challenge government policies across all of the world where they're failing to comply with the duties that we're going to touch on. I'm not going to speak too much about the arms trade because our other two speakers are highly expert in that and are going to say a lot more than me. So I'm just going to hopefully provide a bit of a broader context. So I'm going to focus on 3 points, but I had wanted at the beginning to just say that a sort of short answer to what I believe both what's happened and the legal implications of what happened and what the ICJ has already said. And I agree with you about the importance of the arrest warrants being issued by the International Criminal Court chamber in November that you touched on earlier. But my short answer to where we are really with the duty to prevent is it's clearly been triggered, arguably from a very early point in time in October 2023, but unarguably, in my view, since the first ICJ order in the case brought by South Africa against Israel at the International Court of Justice. And that duty requires positive steps by states to prevent these daily atrocities. And in my view, that duty or the failure to comply with that duty can be litigated as part of what I become, as I said, touch on the second O, will become a feature of domestic cases, including here in the UK, and in particular, but not exclusively, and I will tend to focus on this concept of due diligence when I get a bit further down the line. And I think it's really important because we're not going to cover in as much detail as I would have hoped today. And I see that one of the attendees is Ralph Wild, and I'm going to fairly shamelessly plunder an opinion of his that was published on the 1st of December, with which I wholeheartedly agree. So if there is a discussion of the ICJ advisory opinion and what it means, the third-party state duties, I would defer to Ralph to answer any questions, but certainly put to me, because I don't think I can better what he would say on it. Anyway, I'm going to move on to the 3 points that I'm going to touch on, hopefully within the 20 minutes that's been allowed to me. And I've already used up almost 5 of those, so I'll speak quickly. So I'll touch on the duties of third parties to prevent genocide, which already mentioned, but I'm going to do it in a slightly more detail, and in particular touch on the Nicaragua versus Germany ICJ case, notwithstanding the fact that the court in that case refused to make an order for provisional measures. I'm going to touch on, and as I mentioned already, with the help of Ralph Wild's analyses, the importance of what is said in relation to the duties of third parties in the ICJ advisory opinion from July of 2024. And finally, and extremely briefly, I'll touch on the news stories there have been both in France and in Poland about the possibility of Netanyahu traveling while he's under an arrest warrant to those states, which are both parties to the Rome Statute. And not for today, so just a sort of throwaway remark, touching on my real area of expertise, and I'm going to be talking about areas which I'm passionate about and which I will be involved in litigation about, particularly the duty to prevent genocide, I hope, if the government doesn't comply with those duties pronto. My real area of expertise is universal jurisdiction, as I think you mentioned, and it's a reminder that the UK has positive obligations to exercise universal jurisdiction over all those suspected of committing war crimes. That's grave breaches of the 14th Geneva Convention. And the treaty obligation is explicitly to seek out and prosecute or extradite to another country those suspects. And looking further abroad beyond, of course, the UK, just a reminder that the Clooney Foundation's project, Justice Beyond Borders, a global mapping tool, which you should all be familiar with if you want to understand the scope of UJ, shows that there are 148 countries that have domestic legislation that allows for universal jurisdiction. So quickly, moving to the first topic, the duty to prevent genocide. Well, the clue really is in the title of the convention on the prevention and punishment of the crime of genocide, 1948. So it's clear that states aren't supposed to wait for a finding by any judicial body that there is a genocide. They have a duty to prevent the genocide. And what does that mean, and how is it triggered? Well, it's clearly been triggered, as I said, and arguably, but it's a kind of sterile argument, really, because certainly since January of 2024, there can be no doubt, and I'll spell that out in a minute. But just to remind everyone that the Genocide Convention, and by the way, the duty to prevent genocide is considered to be a duty regardless of whether you're a state party, because of the significance of genocide as a crime. But the states parties to the Genocide Convention number 153 states. So it's one of the more popular international treaties, if you like. The UN Charter has 93 state parties. The Geneva Conventions have 196 state parties, and the Rome Statute, as a contrary example, but still quite a popular treaty, has 124 states parties. So, the world over, we have states which are clearly bound by their treaty obligations, in this case, to prevent genocide. And I'm going to plunder a couple of other articles, as I said, not just that of Ralph Wild on the ICJ advisory opinion, but on the duty to prevent very early on, Jinan Bestaki wrote a fantastic, relatively short, very accessible article, which I highly recommend to everyone. It was published as early as February of 2024, so soon after, just a couple of weeks after the first order in the South African proceedings. And she wrote a further blog in March, and Nima Sultani has written in May of 2024 following that march, the march, which is the second order that was made by the ICJ in the case, critiquing quite properly, really, how the court failed to really enlarge on the duty to prevent. And he does many other things in that article, but I recommend all of those three because they're highly accessible. Put simply, the genocide is underway. All states have a moral and legal imperative to act. Lawyers acting for relevant clients who have a standing in their jurisdictions are struggling to pin down what this means. But in the case of the arms trade issue, which was initiated before any of those decisions was made, it's a very important judicial review, which will hopefully explore the contours of that in the context of the arms trade. But as others are talking about that, I just mention it, and it's already been mentioned by you, Michelle. So in essence, the provisional measures that were ordered by the ICJ in January 2024 spelt out and referred to the key crimes under the convention. And just a reminder, I'm sure that everyone, well, I hope everyone doesn't need telling what they are, but let me remind you nonetheless. Article 2, in the present convention, genocide means any of the following acts committed with intent to destroy in whole or in part a national, ethnic, or racial or religious group as such. A, killing members of the group. B, causing serious bodily or mental harm to members of the group. C, deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part. Imposing measures intended to prevent births within the group. Forcibly transferring children of the group to another group. Now, there is evidence writ large, and there already was when the hearing took place at the ICJ in January 2024. And appallingly, we have another 12 months of evidence since then of each of these individual crimes with the necessary intent. And again, read Nima's article on the nature of the intent and what, by the way, 6 countries put in the Myanmar proceedings as to how intent should be more liberally interpreted by the court in future. But setting that aside, and this isn't a session about the evidence about intent, what the key findings back then in January were: there was a plausibility that Israel is committing acts that constitute genocide, those acts that I've spelt out just a moment ago. That's paragraph 54. There existed a real and imminent risk of irreparable harm to the rights protected under the convention. That's in a separate paragraph. And then at paragraph 33, the court opined as follows: all the states parties to the convention have a common interest to ensure the prevention, suppression, and punishment of genocide by committing themselves to fulfilling the obligations contained in the convention. Such a common interest implies that the obligations in question are owed by any state party to all the other states parties to the relevant convention. They are obligations erga omnes partes, in the sense that each state party has an interest in compliance with them in any given case. And as I say, Jan Bestaki has said helpfully, and again, several articles have been written spelling out the very important provisions of the earlier ICJ judgment in the Bosnia-Serbia case back in 2007, which spelt out these duties in detail. First, the court specified states have a responsibility, quotes, and I'm quoting from various paragraphs. Because of time, I won't give you the full paragraph numbers, but you can find them for yourselves, and they're paragraphs 430 to about 434. To employ all means reasonably available to them so as to prevent genocide as far as possible, particularly those states, and this is an article, the second article she wrote focuses on this, the capacity to influence effectively, those states with the capacity to influence effectively the action of persons likely to commit or already committing genocide. And responsibility is incurred, quote, if the state manifestly failed to take all measures to prevent genocide which were within its power and which might have contributed to preventing the genocide. In a sense, I don't need to go beyond that sentence. That is what the duties are. That's what a breach of the duties could consist of. And I would say that's a relatively low threshold. So responsibility, a failure, in other words, is incurred if the state manifestly failed to take all measures which were within its power and which might have contributed to the preventing. You don't have to prove they would have done had they not taken those steps, simply that they might have. I'm worried about time already, so I need a clock in front of me. So I'm going to have to kind of jump through, but I recommend that you read the rest of that article because of how clearly and well it spells out and cites that 2007 ICJ judgment. And really, she just reiterates the point I just made about the threshold for a breach, and which means, in my view, that is justiciable. That whole issue around where the threshold and what is required of states. And I'll move on to the question of due diligence, because that really emerges from both jurisprudence and something that was said in particular in a declaration in the Nicaragua proceedings. I want to highlight that before I finish. So back on 30th of April of 2024, the ICJ refused the provisional measures sought by Nicaragua against Germany. I won't spell out everything that was sought, but they did include, in particular, an attack on Germany's provision of weapons to Israel, and a failure to fulfill its obligations under general international law by rendering resistance to Israel in its serious breaches of peremptory norms, failed to comply with its international obligations by failing to prosecute, bring to trial, and punish responsible persons. All very laudable points that the Nicaragua drew to the attention of the ICJ. In my talk, I spell out the prepared written talk, but I can't read everything that they asked for in the time available. In declining the order, the court did again reiterate and basically drew everyone's attention to the previous ruling back in 2007 that I've already touched on. And you can see in paragraph 23 in particular of their order of March 2024. So I'm not going to read it, but you should be aware of it. But I think really the important thing to highlight from that is that despite spelling out the law and despite then not making provisional measures, Judge Cleveland, in her declaration at the same time, spelt out the duty to prevent a bit more. So it goes beyond avoiding complicity or aiding in the breach. Now, there's important jurisprudence about complicity, and maybe the other speakers will go beyond the duty to prevent and the duty not to be complicit, because they are slightly different. In fact, they are very different. But just sticking with the duty to prevent, she says, may be breached, quotes, by mere failure to adopt and implement suitable measures to prevent genocide from being committed. Due diligence requires, according to her declaration, an assessment in concreto of the factual circumstances. She also touches on Common Article 1 to the Geneva Conventions, which was cited by Nicaragua in its case, which requires all parties, Common Article 1, to ensure respect for the conventions, and in the context of military assistance, to be proactive in ascertaining and avoiding the risk that arms might be used to breach the conventions. In essence, what I would say is there's no real doubt that the obligation to prevent genocide entails an obligation of due diligence. And Judge Cleveland's separate declaration provides succor for the view that the lens of due diligence is helpful when considering all states and what they're doing. Remember then that the relatively detailed standard which the ICJ set out in the 2007 case, those are the applicable standards, whether the case is conceptualized as a duty to prevent or a duty of due diligence. And there are some jurists who've written specialized books on this subject, and it would be good to hear more from them. But they take the following view. This is Van den Herrick, and Irving, I'm going to cite a couple of the key points that I want to rely on, despite me coming near the end of my time. At the very least, the obligation to prevent implies a risk assessment in respect of genocide, so that the state can know whether the serious risk criterion is met, triggering its obligations to act. It might require a public explanation of how the obligation was taken into account in foreign policy, having regard to the jus cogens nature of the prohibition against genocide. Citing TAMS, states must interrogate their actions, choose a course of conduct, and make public their reasons for it, and then put in place a proper institutional test framework to test decision-making by third states. So it's a process obligations which depends on procedures and institutions. That's the end of my comments on topic 1, and I'm theoretically out of time. I hope the other speakers won't mind if I just say very briefly then. The ICJ advisory opinion. Please read Ralph Wild's explanation as to what the duties of third-party states are. But just to be clear, in the section in the ICJ advisory opinion where it touches on the duties of third-party states, you would not need paragraph 279 if everything in 278 was the whole of the obligation and therefore dealt with, for example, the question of not allowing any settlement products into your territory, etc. So all this notion of it's very, very significant, paragraph 278, but one has to understand that 279 wouldn't be there unless there was something more to say. You could stop at 278 and there'd be a lot to do, which would be focused wholly on the occupied territories, in my view, whereas 279 takes a much wider view and opens the door to a very significant duty. And I would put it very simply, it's BDS. There's a duty to implement boycott, divestment, and sanctions. There's no other way of reading the advisory opinion. And as I say, Ralph spells all that out. I would particularly, in the executive summary, please read pages 4 and 5. I'm not going to read them out because of time. And absolutely is a must read paragraphs 84 to 90 of that opinion, because it spells out in particular the point I've just made, as to how you can't disentangle relations with Israel with its occupation, which is existentially illegal. And I think that's the way I would sort of try and summarize it. And finally, my third area is the ICC's arrest warrant. Look, it's absolutely clear. Netanyahu, if he were to travel to any Rome Statute country, is liable to be arrested and should be arrested, and the states in question must cooperate under their treaty obligations, under Article 87 in particular, to effect the arrest and hand over to the Hague any suspect that's under an arrest warrant. And that's been spelt out most recently in a ruling to do with the visit of Vladimir Putin to Mongolia. It's a ruling in October 2024 by the Chamber Number 2. I was going to read from it, but in summary, they breached the convention by allowing Putin to visit, and all their reasons for allowing him to visit, not be arrested, would apply equally to anyone else under any other arrest warrant visiting any other Rome Statute country. So on that note, and having gone a little bit over my time, thank you again. And I'll hope to stay and answer any questions. And apologies again for not being there in person. I got a bit of a cold. I didn't want to give anyone my germs.
Thank you so much, Daniel. And I'm sorry, I think the fear of guiding to you about time, but actually your comments are always so insightful and enlightening. I would have given you, possibly a lot more leeway. And in general, I will say to the speakers, please don't feel perplexed about the timing. Ultimately, it's meant to be a discussion. And I think we're all here for the same reason, which is that we want to listen to you and to think through the obligation to prevent genocide, which to me is imperative and continues to be at the heart of everything that all of us are doing, scholars, researchers, activists, lawyers in this space, in every way we can. So thank you very much, Daniel, for setting us off on such an important path. Just to reiterate what paragraph 278 says, the obligation to abstain from treaty relations with Israel in all cases in which it purports to act on behalf of the OPT or part thereof concerning the OPT or a part of its territory, to abstain from entering into economic or trade dealings with Israel concerning the occupied Palestinian territory or parts thereof which may entrench its unlawful presence in the territory. And I think Daniel has set out beautifully for us there how that is really the basis of where we should continue these discussions, amongst other many important points. So if I could then turn to Shahed. Thank you so much for joining us today, Shahed. And I think I have actually found the original questions that I had asked, which I had misplaced when Daniel was talking, unfortunately. Do you agree with Daniel? In your view, what obligations do states that are party to the Arms Trade Treaty, for instance, including and in particular the United Kingdom and perhaps Germany, have to cease their supply of arms to Israel? Are there further discussion points that we should be picking up on at this point as well?
Mind if I stand? I think
Not at
it's
all.
easier for
Yep.
the audience. To start with, since we picked up on the ICJ decision, and in that paragraph, the court puts forward this idea that there could be a way to differentiate between what Israel does in relation to the occupied Palestinian territories and what it doesn't. And what Palestinian economists would argue is that there is no way to differentiate between the two. Also, there is not enough information to facilitate any state ever partaking in this. So to take things forward, the question is not what are the economic activities that Israel is doing on behalf of the occupied Palestinian territories versus Israel's own economic acts. The question to start with is, what is the purpose of third state responsibility here? And for us to understand what is the purpose of third state responsibility here, we need to understand what the decision itself entails. If we look in totality at what the court has told us, it has told us that Israel is an infringement of the prohibition against aggression, as well as the people's right of self-determination, as well as the prohibition against all forms of racial discrimination and apartheid. Put all of those in a plus, you would have equal colonization. It is simply alien domination and subjugation, what Palestinians have always called it, what history has always called it, and what people like Ardim Seis called that reality has been diplomatically erased until Palestine became a humanitarian cause, a place that is occupied, where we can say whether or not this occupation is legal or illegal. Taking it forward from there, we need to understand the only way to take the decision forward is by understanding Palestinian self-determination as decolonization. Herein, when we speak about this, our primary precedents would be talking about Namibia, South Africa, Angola, Algeria, all of its other sister causes. And once we take histories of colonization seriously, once we look at the United Nations in the 1950s, 60s, and 70s, that's when we're able to imagine what the international community is meant to be doing. Indeed, we are at a very different political juncture, and what is happening now is not what was happening in the 1950s and 60s. Yet many would argue that perhaps we are reaching a point where politics would be changing, allowing more spaces for us to imagine and put ideas forward as we try to creatively engage with the law. And here I must be very serious. As someone who comes from Palestine, we engage with international law with the prior understanding that this is a body that has been made inherently through a colonial perspective. We engage with it strategically where points that could serve emancipation, which is why the language that we use in how we approach international law is of the essence. And which is why those who are interested in partaking such efforts need to ensure that they know the terminologies needed in order to articulate a decolonization context. This is the language that we need to put forward. What mainstream liberal international lawyers would often try to do is to tell you that that is simply not international law. What Palestine is reminding us is, actually, this is the pivotal point of international law's legitimacy. It's either we call things by their name, or we say that this framework is absolutely useless, as we've seen it happen today. And a lot of the decisions that we will be seeing happening in courts, in national courts and in international courts with regards to Palestine, at the back of them really do pose a question to the legitimacy of these frameworks. They either do the reasonable thing or they simply just become a joke. And sadly enough, places like the ICC have already rendered themselves very close to becoming a joke, have tried to fix that a little bit, but as we see, we are still having issues with taking that forward. With that introduction, in short, what we have in front of us is a state that is committing multiple violations of multiple use cogents and norms in international law. And once we see it all together and we look at Israel's activities both in Syria, Lebanon, and Palestine itself, we find that it's a state that is committing crimes against international peace and security. Call it whatever you want, but this is a state that does not want, or its acts are inherently against the primary premises of the UN Charter. And if there's anything that we've learned about the war economies, is that the prolongation of violations of international law will only lead to more war. So it's either that we don't look at reality and call it by itself, by what it is, or we start to look at it. And it's not just me who would say this, of course. The UN General Assembly has called Israel's acts as crimes against international peace and security multiple times over its history. So moving on to the arms embargo. So to begin with, once we look at all of that, we have, first of all, the duty to prevent genocide, but then the two important duties that come out of the ICJ's advisory opinion, which are the duty to cooperate towards ending the illegal occupation and the duty not to recognize any activities by Israel that come out of this illegality. When we look at those duties together, adding to that the duty to protect under international humanitarian law, among many other duties, we reach a very clear conclusion. And that is an arms embargo against Israel is indeed an international legal obligation. And specifically in relation to the Arms Trade Treaty, it stipulates in Article 6.3 that when there's knowledge that the arms will be used in a violation of international humanitarian law, that's when the license should not be granted. In the case at hand, we have an ICJ decision that calls this a plausible genocide. Herein, there is no more discussion after January last year. This is a space where there is enough foreseeable knowledge that any weapons going towards Israel will be used in violations of international humanitarian law. Furthermore, there is what Israel has been doing in both Lebanon and Syria, which are horrendous violations of international law. Furthermore, the Human Rights Council in Resolution 5528 in April last year distinctly said that states have the duty to take an arms embargo forward. A very big question mark as to why we don't have a decision for an arms embargo by the General Assembly. And my main answer to that would be to you is politics. And that's where the politics of international legal making plays. And most importantly here, the question of representation and state will. For the Palestinian Authority to be called as the legitimate representative of the Palestinian people is inherently something that violates a lot of what could be said to represent Palestinian self-determination. The Palestinian Authority is at the moment working under what can only be described as different forms of coercion. And different forms of coercion and interest collided into each other to form its position on the international fora. Despite work by what can only be described as an army of international lawyers building the momentum for an arms embargo, we reached a point where we were at a political deadlock, where the words of justice and the words of international law were just rendered meaningless by a very thick layer of old white men and a very thick layer of also old Palestinian men. They tend to be older, the Palestinian men. So with that, we've reached a point where we do have a clear duty for an arms embargo, whether the UN General Assembly would like to call it or not. From the UN General Assembly's resolution on the advisory opinion, we can indirectly say that there's a duty for an arms embargo as well. Furthermore, the Arms Trade Treaty tells us that the transparency is the core of this treaty. We need to be clear about what states are buying and selling. What we're seeing is a horrendous lack of transparency. In Australia, lawyers try to go and ask how much are we selling, how much are we not? And what we received was nothing, was okay, ambiguous. The same with Germany, the same with the UK, and the same with Canada and France. And a small comment in relation to the case of Nicaragua versus Germany. While the International Court of Justice did not agree with Nicaragua, the International Court of Justice committed a humongous mistake that no one who's ever studied the war economy would agree with it. The court said that based on the evidence given to it, that Germany hasn't given that many weapons that are destructive to Israel. And it took forward a differentiation that is completely made up by Germany, lethal versus non-lethal weapon. If you've ever heard of a non-lethal weapon, come talk to me. Oxfam has been talking about how unrealistic this differentiation is since 2005. They created this thing. So a door of a warplane is a non-lethal weapon. The shell of a bomb is a non-lethal weapon. There is no way that we can understand by which criteria does Germany decide it is sending lethal versus non-lethal weapons, and the ICJ took this forward. What this tells us about the law is, one, the lack of technical expertise. And I've met ICJ judges. In reality, these people are so overworked with very minimal researchers. And there's a very big question as to whether or not that comes in by design. As we speak now, there's another thing that is happening by design, which is that Judge Salam is being asked to become the Prime Minister of Lebanon, which poses a very big question. Out of all of the Lebanese people, you chose the head of the ICJ who could have really helped us go forward with the genocide case. And this is not the first time this happens. But here you also see the politics that happened in the International Court of Justice, the indeterminacy in the genocide case, and here simply taking out the leeway offered by Germany through this fake differentiation. So the duty to impose an arms embargo also extends to the transit of arms, and that comes directly from the Arms Trade Treaty of Article 9, where no state shall authorize the transfer of weapons when it knows that they'll be used in violation. And we have had a huge problem with that. Over the past few months, activists all around the world have been scurrying around to, one, find out about the transfer of shipments across the world. You must have heard about different cases. And two, try to stop them. And sadly, what we have found is a huge reluctance by states. States like Spain and Ireland were willing to work with us. Meanwhile, states like Morocco and Egypt and Malta was a bit hesitant. It did help us out a little bit, but sadly, Egypt and Morocco did not. And by that, transit can also be described as a form of complicity when we are looking at a case of genocide, because you are knowingly facilitating the transfer of weapons to a state that is committing genocide. And this question will be posed in the future. I'm sure Irena will talk more to this, but also this extends to jet fuel. An argument can be made that jet fuel, which is fuel that is specifically used for warplanes, is a component of those weapons. Of course, you could argue for an energy embargo under other premises once we build, as I said, on the precedents of other cases of decolonization. Energy embargoes were used in the case of South Africa and were used in other cases, specifically in relation to the Portuguese colonization. And so, it's important to also note that the duty of arms embargo overrides other duties and other international obligations, which is something that the US as well as the UK and the rest of Europe seem very reluctantly to take on board. By that, I mean, when the UK was confronted by Al-Haq and Glan, it indirectly noted that it has a carve out space for weapons that go, or specifically parts of warplanes under the F-35 program by the NATO. And the F-35 program by the NATO is basically, we have F-35 warplanes, and the NATO and the supply and maintenance of those weapons is supported through this program that goes through different states. So here, what activists around the world have been trying to do is to disturb the F-35 program, which are, of course, leading these warplanes are those same warplanes that are dropping bombs on people in Gaza. And the argument here, and we've seen the same argument come from the Netherlands, is that NATO obligations must override international law. They haven't said that, but they said that this is a foreign affairs type of decision that is to be carved out of what the court can rule on and not. Said in different words in the UK and the Netherlands, but the same conclusion. But here, people must be reminded that the NATO agreement can only be read in a harmonized reading with international legal obligations. Nothing in the NATO agreement says that the F-35 program overrides international legal obligations. Sadly, state representatives would like to overlook this. Furthermore, the idea of other obligations. When confronted with its facilitation of the transit of weapons through the Suez Canal, the Suez Canal authorities responded saying that they are bound by international treaties, so by the law of the sea, but also specific in treaties like the Constantinople Treaty of 1888, as well as later agreements to facilitate that the transit of that ship. However, Article 53 of the Vienna Convention says that any conditions in a treaty that collide with a Hughes-Coggins norm, the Hughes-Coggins norm prevails. And here we are looking at a state that is in violation of Hughes-Coggins norms. And what is a more important duty in international law than the prevention of genocide? These things ought to be logical. We ought not to be in conversation with states to convince them, but sadly, this is the absurdity of the world we live in. And as a side note, in relation to trade agreements, and I would like to reiterate what was said, the trade agreements can also, in this case, states can breach them, even though the GATT does not apply to arms. But as a side note, in relation to trade with other things, Article 51 of the GATT says that it is possible to override trade obligations if it is to induce compliance or in relation to compliance with the UN Charter. And here we are once again talking about violations that touch the very core of the UN Charter. So going further, the use of economic coercion is prohibited. And sadly, this is not a rule that is taken to the forefront of international law. Why? Because economic coercion is the main tool of neo-colonialism. So it wouldn't have made sense for states to allow this to become an important tool of international legal making. However, what I mean here by economic coercion is that the US is fighting a war with any state that decides to uphold its third state responsibilities towards the case of Israel. So we're talking about what the US has been doing in relation to Spain, in relation to Spain, in relation to Ireland, and what it has done in relation to the ICC in the past few days, which is through defunding the ICC. People at the UN now are talking at a mass level in relation to the defunding that's going to happen through the Trump administration, but also what the US usually would do when any state goes outside the international order, as instated by its imperialist aspirations, is that it would impose on some level some sort of trade measurements that would affect the economy of that state. We've seen also very similar measures being taken against South Africa in retaliation for what it does. So here we must remember that in the annex to the Vienna Convention, there was a direct reference to the prohibition against economic coercion. Why that wasn't taken to the Vienna Convention itself, we have France, Belgium, and a few other European states to thank for not allowing that to become a part of the convention. However, this still can be developed and argued for as lawyers. Moving on to the UK's case. So as you're all very aware, there was a case, and currently there is a case, the procedural in the UK in relation to the arms embargo. The procedural bit has been is over, and now we're looking towards the hearing, which will happen March by the earliest. And here, what is happening is that this new application is trying to reference a criminal law criteria of aiding and abetting. It was taken forward in November after the arrest warrants. So it has, the arrest warrants gave new life to the judicial review in relation to the arms trade. The question of how the UK government will handle this is still open. Sadly, I don't have much else to add to that case, except that it's still being in the UK. What happened is that there was a suspension of only 30 out of 350 licenses. A recent report to the logic behind this has been released a few days ago. And in general, the UK for the longest time kept on saying that Israel is not committing violations of international humanitarian law. And as you can imagine, with the conflicting decisions and positions being put forward, the public are just being swayed towards being confused about what is happening. Furthermore, another thing in relation to the UK that is often also undermined and overlooked is the fact that it has been revealed that the UK has conducted surveillance flights over Gaza over the past 1.5 years. So the UK has direct knowledge of the ongoing genocide, and given its material contribution also to Israel's supply chain of weapons, alongside its facilitation of surveillance, God knows what these surveillance flights were being used for, there is very strong grounds to argue for complicity in relation to the UK. As to other cases, the same mechanism of judicial review is being taken forward in multiple other states. We're looking at the same happening in Canada as well. Some are trying to do the same also in Italy. And we'll finish on options of litigation for the arms embargo. Since states are demonstrating a very clear lack of political will to take their obligations forward, the only way forward will happen is through advocacy and taking this forward. This is a very long fight, but the premises are here to stay. So the first of which is freedom of information requests. So for example, in Belgium, they've done freedom of information requests under environmental laws in order to get information on the contents of bomb powder or explosive powder, sorry, that Belgium exports. And since we are looking at a supply chain that is primarily led by the United States of America, the idea then is to try to hit the supply chain in other places and try to find other states that are willing to take up their obligations. Judicial review, of course, cease and desist letters to these corporations, using the UN mechanisms to pressure states, as well as criminal cases against arms corporations. Bits and parts of this are happening all around the world as we talk now. Even in India, there was a case at the Supreme Court that was rejected. Letters to MPs are also very useful. I've spoken to MPs in the UK, and the level of ignorance that I found is insane. We're now also looking towards coalitions among global South states. This is anyway happening with the changes in the geopolitical making of the world as we look at it now, with the changes in BRICS and whatnot. But we are also looking at, for example, the Organization of Islamic Cooperation and the League of Arab States have indeed called for an arms embargo. So taking such coalitions forward, focusing on states of the global South and trying to hit the supply chain where it hurts is the current strategy going forward. Thank you very much.
Thank you, Sharon. Very importantly, putting us into conversation with the economic realities and also the obligations under the Arms Trade Treaty, or lack thereof, it would seem, of states to prioritize both the obligation to prevent and to not aid and abet through the transfer and sales of arms to Israel, the ongoing genocidal acts that are occurring. I think you've put into play a number of different important issues, including the obligation of conduct versus the obligation of result. And I think this is where we see that despite the focus on due diligence that Daniel raised through Judge McDonald's decision and the fact that this could be helpful, due diligence continues to be an issue where we wonder whether it's sufficient and doing enough to ensure that the obligation to prevent, in effect, becomes paramount in our discussions about what's happening in Palestine and the ongoing injustices underway. So I'm very grateful then to be joined by Irene, who, of course, is herself a business and human rights expert of some repute, and whose report very extensively delved into the importance of the obligation to prevent from the perspective of third-party states and private actors in addition. And what are the implications then for both the arrest warrants and the ICJ's decisions for UK weapons manufacturers and private military and security companies in Gaza? Can a distinction be made between those who publicly align with the UNGPs and those who do not? But additionally, what are the obligations upon states, according to you, Irene? And anything further you wish to add from your brilliant report would be very much welcome. Thank you.
Thank you very much, Michelle, and good evening, everyone. So I will divide my presentation in two parts. So the first is about the obligations of private actors, focusing, of course, on arms and weapons manufacture. And second is what's actually happening in the UK, developing a bit more for what just has been discussed by Shahad. So in relation to the obligation on private actors, specifically the implication of the ICJ orders for corporations that have operation or business relationship with Israel, so moving from what are the obligation of third states that we heard about. The prohibition to commit genocide is a jus cogens norm. So from this norm, no party, including corporation, can derogate. In general, in situation of armed conflict, the international humanitarian standard apply to corporation as well, and apply to also individual business leaders. So they need to consider whether the operation contribute to violation of international standard during an armed conflict. The UN Guiding Principle of Business and Human Rights, which are a non-binding instrument, but they create expectation on business, and they have now become part of hard law in a number of European countries. They also provide that business should respect the standard of international humanitarian law in situation of armed conflict. So because of that, corporation and their managers could be liable for the commission of acts of genocide in Gaza. Article 6 of the Genocide Convention clarified that persons may be liable for genocidal act. So because person includes individual businessmen as natural person, it may also include corporation as legal persons. Because this, of course, is happening also in the context of the ICC arrest warrant that have already been described. Just to, of course, restate that the ICC does not have jurisdiction over legal entities, but company personnel, manager as natural persons of state party of the Rome Statute may, in theory, fall under the jurisdiction of the ICC. So that's also should be noted. when we talk about corporate complicity, this implies the concept of corporation may be hiding and abetting genocidal act perpetrated by another actor, in this case by the States of Israel. So international criminal law suggests that direct complicity requires intentional participation, but not necessarily an intention to do harm. Actually, only knowledge of foreseeable harmful effect. So as such, corporation or corporate leader may be complicit in the commission of genocide where they decide to participate through assistance in the commission of the act by the State of Israel. And if it can be proved that that assistance has a substantial effect on the commission of the crimes of genocide. So corporation investing or partnering with the Israeli government or also with Israeli state-owned enterprises face really a salient risk of aiding and abetting genocides, as well as other violation of international humanitarian law. In particular, of course, arms, weapons, but also ammunition, vehicles, other military supplies, including technology and including fuel, as was mentioned, really are essential to the activity of the Israeli Air Force, ground forces, Navy as well. So they do make this essential contribution to violation of international humanitarian law in Gaza. Since the beginning of this war in October 2023, dozens of companies domicile on interstates, especially in the US and Germany, but also in the UK and in other countries, and we'll now move into the UK situation. But they have been and they are still currently providing Israel with weapons, other military equipment, also technology. They are doing so knowing that their supplies are used in Israel war in Gaza. Obviously, they cannot say otherwise. So these companies and their manager risks charges of complicity in genocide and other international crimes that can happen in their home states, so in the states where they are incorporated, so in the Netherlands, for example, or in Germany, or in the UK, or in the US, or in international courts. In relation to the concept of human rights due diligence, which is different from the due diligence concept that was mentioned earlier, that refers to an obligation of third state. This is like a corporate human rights due diligence. So business that have operation or business relationship in Israel, so just like, let's say, any business, should address a range of complex risks and impacts that relate to the conflict and to the root causes and their impact on the wider economy. This is based on the concept of heightened human rights due diligence. That is an international standard clarified by the UN. So this company must conduct heightened human rights due diligence regarding both their operation and their whole supply chain in order to identify risk of where they may be contributing to violation against the Gaza civilian population. Generally, under the UN Guiding Principle on Business Human Rights, as well as the OECD guidelines, so let's say generally under the Business Human Rights Framework, before considering ending relationship, companies should seek to be part of the solution of the problem, so by addressing adverse impact through exercising leverage. But there are special considerations in cases of possible complicity in gross human rights abuses. In relation to the current situation of Gaza, it's clear that business enterprise lack the leverage to prevent or mitigate genocide or other violation of human rights. So they need to end any existing relationship, in short. This is important because independently from state regulation, so even if their home state don't do anything or don't impose an arms embargo, still companies have their own responsibility to abide by international law as recognized by the UN Guiding Principle and the OECD guidelines. And the UN Guiding Principle clarify that this responsibility is over and above compliance with national laws and regulation. So companies whose activities, products, service are directly linked to severe human rights violation currently happening in Gaza are expected to consider responsible exit, responsible disengagement, and they need to leave. I want to repeat that because it's important, even if their home country does not require that, or they are not under sanction or any sort of legal requirement. So companies that provide weapons, arms, ammunition, technology, oil and fuel, intelligence, artificial intelligence, other military supplies to the government of Israel should stop any further operation to avoid risk being directly complicit in the ongoing violations. Now, moving to the second,
Just before you continue, I'd like to just intervene to note for the audience that many, if not all of these companies, several of which are engaged in arms trade, have policy commitments which state specifically and explicitly that they undergo their operations in accordance with the United Nations Guiding Principles. Just add further gravitas to what you've just said. Please continue.
Yes, exactly. So in short, those companies are not respecting their commitment under the UN Guiding Principle and are not conducting heightened human rights due diligence as expected by the UN standards. And again, I reminded that now those concept of human rights due diligence are part of the national laws of a number of European countries already in force in Germany, in France, in Norway, and soon to become law in all European Union member states, as the EU has recently, last year, passed the so-called CSDDD, Corporate Social Responsibility Directive, which will mean that in the next 2 years, all EU member states will have to have in place a law that require companies to conduct human rights due diligence. So those companies are not, obviously, are not doing that. Just to clarify also, the position in the UK. So even if the primary source of arms for Israel are the US and Germany, the UK has granted licenses valued at about £42 million in 2022. And even if it dropped to 18 million, according to the government, in 2023, still has granted more than 100 licenses for military and also non-military control goods to Israel between 7 October 2023 and I think the last figure was like May last year. So these licenses are assessed against the UK strategic export licenses criteria. These criteria say that the government will not grant a license if it's determined that there is a clear risk that the items might be used to commit or facilitate a serious violation of international humanitarian law. So there was a review by the Conservative government of the export that concluded that the government in December 2023, that the government was satisfied that there was good evidence to support a judgment that Israel is committed to complying with international humanitarian law. And so they did not suspend or revoke any license, but just kept them under review. So then after taking office last July, the Labour government also had like a fresh a review, like an assessment of Israel compliance with international humanitarian law. And so it announces in September the suspension of about 30 licenses out of about 350 to Israel. So he said that for certain exports, the government had concluded that there was this clear risk that they may be used to commit or facilitate a serious violation of international humanitarian law. So this includes, for example, components for fighter aircraft, the F-16s, parts also of unmanned aerial vehicles, naval system, and targeting equipment. But licenses are still permitted for items that the government assessed that are not for military use, specifically in the Israel-Hamas conflict. So it's just a suspension of some arms, but it's not a blanket ban or an arms embargo that instead has been called by civil society and the UN. So the justification is that the UK said that Israel must have the right to defend itself against other, for example, Hezbollah is based in Lebanon, the Houthis based in Yemen, and in particular, there is the F-35 exemption. So the Foreign Secretary, the UK Foreign Secretary, the Business and Trade Secretary explicitly said that the exports to the global F-35 program will be excluded from the suspension decision that was announced in September, except where they go directly to Israel. They say that this is because the global F-35 supply chain is vital for the security of the UK, their allies, and NATO. And also they mentioned that it will affect Ukraine. So they also justify that, say that they exported to the US, so they export this component to the US where they are assembled or become part of other components. So they kind of lose sight of the components once they leave the UK. So this rationale of permitting these exports really seems in conflict with the UK obligation under international law, and the international humanitarian law, and the Genocide Convention, and also under the Arms Trade Treaty. Like a similar case was also decided is under actually is ongoing in the Netherlands, because the Netherlands also with us F-35 part distribution base has halted at the moment direct export of F-35s following a local order last February. But now the Dutch government is appealing the ruling, and the Supreme Court is about to decide. But as I mentioned, this seems to be in contradiction, like in conflict with Article 7 of the Arms Trade Treaty, which calls on signatories, including UK, not to authorize the exports of goods if there is an overriding risk that the items could be used to commit or facilitate serious violation of international humanitarian law. So this is, I cannot see how the UK can legally defend a position to keep those arms export license open. Okay, I think we are over time, but just to conclude is that another point that really it cannot be overstated is the role of software and tech company, including artificial intelligence providers. And there is also a risk that the UK may be also providing some technology that could be used by Israel in many of their AI tools that has been shown to being able to automatically target civilians. And this risk is also because what also Shahad said is a complete lack of transparency under the open licenses. So the UK can sell things that say that are not covered by individual license under this broad open license, and this could include many tools and systems, including AI technology that could be used in serious violations. Thank you.
Thank you so much. Well, the discussion has been both broad and deep. I'm sure you will agree with me in thanking all three presenters for what has been a panoply of showing us essentially how the obligation to prevent is being undermined, and additionally how companies themselves can be held responsible to undertake heightened due diligence, which obviously is not going toward where we would assume it would, which would be to prevent them from maintaining trade relations and exporting ongoing goods to Israel. So I now turn to our discussant for the evening, Dr. Nima Sultani. Nima, perhaps if you both comment and then start us off on some of the questions, because I'm sure there are audience members who would follow your comments with further questions as well. Thank you.
Thank you so much, Michelle, and for the speakers, Shahd, Daniel, and Irene. As Michelle said, this was a very comprehensive and detailed discussion, so I don't have much to add. So I thought I would just kick off the discussion with making two general comments or provocations and ask the speakers to perhaps respond to them, and then three kind of tiny questions for each of the speakers. So perhaps they can expand upon them, and then hopefully others will join the discussion. So the first comment or question, is it possible to have an effective duty to prevent international? Is it practical to expect a duty to prevent to be discharged by state in the current global system? Is it likely that the duty to prevent international law will ever be implemented, specifically when we talk about such a situation like Israel? Consider the three following considerations. First, prevention presupposes identification and naming of the crime. Now, specifically when it comes to Israel and Palestine, we have seen this since October 7th, the unmediated, straightforward, automatic solidarity with Israel and sending arms to Israel and standing with Israel and going to have photo ops with Israeli leaders, etc. And then the delay and foot dragging, not only with respect to genocide, but also with even saying things like war crimes or crimes against humanity by influential states, but also with respect to UN agencies. UN agencies and human rights organizations still at this moment mostly talk about hostilities. And in the beginning, I thought the passive language, not naming Israel was maybe kind of not something inherent. But when you see it day after day after day by the WHO and by the UN agency and by UNRWA, even when themselves are being attacked by Israel without naming Israel. So even these kind of tiny incidents, daily incidents, there's a delay or lack of naming. Think of the Amnesty International apartheid report. What did Amnesty conclude in 2023? They concluded that the Israeli legal political system, what they call the totality of Israel's laws and practices since 1948 are an apartheid system. So they could have said that many, many years before 2023. Human Rights Watch reached a similar conclusion. They just called it an institutionalized system of racial discrimination was established since the beginning of the state. So there was nothing new in reaching the conclusion about apartheid in 2022 and 2023 by Human Rights Watch and Amnesty International. But for different reasons that we can discuss, some of them might relate to racism, anti-Arab racism, anti-Muslim racism, anti-Palestinian racism, Orientalism, whatever it is, given the identification of Israel as the Western force, and given the identification of Israel as a Western outpost in the Middle East, there was this lack of naming or this delay of naming and the foot dragging that we saw on the ICC and elsewhere. So bias, normative backgrounds for the prevention duty. And then secondly, if you think about the subcategory in this, the capacity of influence. We talk about the states that have the capacity of influence. These are Western states. But this is a Western genocide in the sense that it's supported, armed, financed, and politically shielded by the very states that have a capacity of influence over Israel. Given the fact that Israel isn't within Western alliances, the states that can influence it, the states that have extensive economic and military and political and diplomatic relations with it are the Western states, are the very states that we talk about as either complicit in the genocide, and in the second best scenario, are those that fail to prevent the genocide. So how do we expect those who have the capacity of influence to influence Israel in order to discharge their duties to prevent, when they themselves are primary kind of joint criminals in the enterprise of the crime of genocide, or at least war crimes and crimes against humanity? Secondly, the geopolitical factors. Consider the US imperialism and the role of the Israel in that US geopolitical vision of the world. As you all know, Israel is the primary recipient of US aid. When the US arms Israel, they keep talking about maintaining the qualitative military advantage of Israel over the region. So whether it's defensive or not defensive, it doesn't matter. Eventually, it serves the same role, which is maintaining the dominance of Israel in the region as part of the American and slash Western vision of the world. And finally, within this geopolitical factor, the ability of the US to blackmail other states that might be able to discharge their duty to prevent. There's a lot of talk now. I was just reading today an article about South Africa and kind of different economic interests that Trump, once in power, he can endanger these interests. Morocco has been silent, for example, since the genocide, because they got from Trump the Western Sahara gift earlier on. So there's different kind of horse trading or blackmailing that might be intensified now that the Trump administration in power soon. And thirdly, there's the economic factors. When we're talking about arms trade, this is a multi-billion-dollar industry. Year after year, we have, like, I think 2023, the main 5 states had $85 billion of arms trade. Israel is one of the kind of major countries. I think a couple of years ago, it was like number 15 in the arms trade. There are billions of dollars going between EU states and Israel in terms of arms trade. Serbia was in the news the other day because they bought a lot of arms from Israel. So the arms industry exists for a reason that war is profitable. They are making profit from war. And if you combine that with the fact that in many Western or capitalist political systems, there is a corporate capture of the state. There's a lot of influence of the business elites on state, on decision-making, while the rest of us are isolated or marginalized from proper democratic forms of accountability. Combine that also with the fact that in many states like the US, but also Britain, there's a lot of influence of money on politics. You remember in the US a few years back, there was a case during the Obama administration called Citizen United, in which the Obama administration wanted to limit a little bit the influence of money, the corrupting influence of money on politics. And they couldn't because the Supreme Court, which is a right-wing institution, prevented that. So that leads to the situation today in which corporations have a lot of influence, and many of these corporations are arms trade corporations. So the question is, how does that, what does that tell us about the ability to have ever a realistic duty to prevent? Second comment/provocation, more briefly, what does the efficacy or lack of efficacy of the duty to prevent tell us about international law, about the nature of international law, about the efficacy of international law, given the fact that international law relies on state compliance, state enforcement, state duty to prevent, etc. For example, if you remember, I was just looking at February 2024, there was a statement by different UN rapporteurs saying there has to be an arms embargo. And then, as Daniel said, the ICJ in April said, we remind you in the Nicaragua case of your duty to comply with Article 1, the Geneva Conventions, etc., and not to supply arms that might be in the part of the commitment of crimes. So what does that tell us about international law? The more specific questions, Daniel, can you say something more about the ICC arrest warrants? Specifically, there was a comment in the warrants in which the pre-trial chamber indicated that some of these crimes and crimes against humanity are ongoing. So it's not only that these arrest warrants about, which was requested in May about crimes that were committed before May, but the ICC was itself saying that these are ongoing. So what does this tell us about the duty of third parties to prevent and ensure compliance with international law? The second question, Irene and Shahd, can you say something about universities in terms of, third parties, including corporations? Thirdly, Shahd, can you expand more a little bit, something you said in the beginning of your presentation? Now, if you look at the ICJ advisory opinion, when they make clear, obviously the question from the General Assembly was also as such, they make a distinction between 1967 and so-called Israel proper. So the duty to not render assistance is related to the settlements and the ongoing violation, the ongoing unlawful occupation, etc. But if the Israelis themselves, and there is a lot of states now that are paying lip service to the two-state solution. But the question is, can we maintain this distinction between Israel proper and the occupied territories when the Israelis keep telling us that they want to annex? The ICJ itself said the distinction between de facto and de jure annexation is really not that material. What's important is the actual and practical reality. And the Israeli Basic Law of 2018 said basically that Israel has, or the Jewish people have, the right of self-determination over all of the territory of the land of Israel. So if you can say a little bit more about that, how that can impact our understanding of the duty to, what Daniel said, BDS, following these two paragraphs in the ICJ. Thank you very much for all of you.
Thank you, Nima. So perhaps if I start then with Daniel's reflections, or we can take it in whichever order the speakers prefer. Having you both on screen makes it a little bit more challenging for me to read the room when it comes to the speakers. But Daniel, perhaps if you start.
Yeah, I'm happy to respond. I mean, I don't have any dispute with some of the critique that Nima put forward, obviously. But I would say that in relation to the first question, the first general point, is it possible theoretically and possibly in other circumstances to have an effective duty to prevent? I think the answer to that must definitely be yes, despite the powerful element of the arms trade per se, which makes it problematic to have an effective duty, even in a situation where there isn't so much support from the arms industry generally and from states that house some of the key elements of the arms industry, as we've got with Israel. So I think it is possible. We're just up against everything that Nima said and more. Though it was pretty comprehensive, Nima's explanation as to why, in fact, this duty isn't being implemented, and it's worse than that. We've got complicity. We've not only got a failure to prevent, but we've got active participation, which we sort of touched on slightly, but there could be a lot more we could say about that. What isn't in a lot of what Nima said, but I don't think he'd claim it, is much legal debate or argument about that. This is realpolitik that he mentioned, all of which we've got to deal with. And when I'm not assuming that we can successfully deal with it currently, given global politics and the power of Israel and the pro-Israel lobby in various states, but it doesn't even need that. It's the as it's seen, the objective interests of states, even when faced with the duty to prevent a genocide. So the only thing that we can do as lawyers and activists is to keep on making the legal arguments, because the legal arguments should win. They should win the day in a world which doesn't have all these realpolitik problems attached to them. And the best we can do, and I don't think we've got any other option, and we don't have the privilege as a Palestinian lawyer has said, Raji Sourani, many times, we've got to maintain a strategic optimism, because that's what is required of us by those struggling day to day with trying to make sure that things do change. So we've got to keep using law and the arguments that exist in the law to try and vindicate those rights. We don't have any other option, but we're up against so many of those obstacles that Nima mentioned that you can only call it strategic optimism. You can't call it any other form of optimism. In answer to the direct question he put to me, yes, of course, the allegations against that formed the basis of the arrest warrants persist. The starvation policy persists. Nothing's happened since November to stop that happening, and it's another outrage. And of course, it just strengthens the case because, and it strengthens the basis on which the further charges should be brought, because one of the most disappointing aspects, and we haven't really touched on it, is the scope of the crimes covered in the arrest warrants and the scope of the defendants. I mean, just look at what we've got with the two defendants. To implement a strategy of starvation, why isn't the chief of staff of the Israeli military there? Why isn't the head of Kogat, the body that implements the policies, day-to-day policies on access of food and water and all provisions across into Gaza? They're clearly the right defendants for these particular crimes. So there's so much more to do in all these areas. And as I say, while we're banging our head against the brick wall, I don't believe there's any other option but to continue to put the mirror up, the legal mirror up to all states and require them to address it. And that you can do that through litigation. And that is something that we just must continue to do as those of us who can litigate.
And perhaps I can just very briefly address the question of academic institutions. Also, I'm sorry, I need to leave in the next 10 minutes. Yeah, so there have been like an academic boycott actually for the past 20 years. Of course, the situation clearly has worsened. Just to mention one aspect of the responsibility of university or academic institution in relation to the arms and weapons, and in particular the use of software, technology, artificial intelligence. It's actually that these technologies, which are mostly actually Israeli. So even if earlier I mentioned also the responsibility of companies that are domiciled in third states, most of the technology companies are actually Israeli companies. They run those programs that you probably heard about, the one called the Gospel, that can generate targets almost automatically, or like another AI-based program is known as Lavender, that can identify people and put on a kill list. There is another one called Where is Daddy, that alerts the Israeli army where Palestinians on a kill list enter their family homes, and many others. So those, of course, those programs, those systems have been developed in research institutes. And they have been so researched there and also tested and used against the Palestinian people. So just to mention one aspect. So this long boycott is now we're really seeing like a growing number, especially of European universities that are ending their ties with Israel, including especially in existing Horizon Europe projects. In particular, I'm aware of many Spanish universities that decide to suspend research exchange and any ties, for example, the University of Granada, the University of Barcelona, Also Irish universities, for example, Trinity College, Trinity College of Dublin, also agreed to divest from Israel. So there have been like many examples of that.
Thank you. Thank you, Shahad. Perhaps if you could close us then with your final comment.
Thank you, Namir, for the questions. So to start with, international law is sympathetic to both colonization and imperialism. That's just a historical fact. It's structurally embedded within the language of international law. The indeterminacies of international law are designed in a way that makes this quite elusive and that make us stuck in an order. And this has been very clear in the past year. To give us some sort of an illusion of agency as we try to go ahead. As a part of colonization is genocide. People have been warning about this happening in Gaza ever since 1948. This was expected to happen ever since 1948. It is just that we live in a world of cultural imperialism where histories of colonization are so erased from history that people just simply forgot that genocide is a very normal process in colonization. Meanwhile, in relation to imperialism, as Rosa Luxemburg reminds us, capitalism will always lead to imperial expansion. Imperial expansion will always lead to expansion of militarism. So, and we've seen that, of course, the arms lobby has a very big role to play in why the war still hasn't stopped. And also, as Ali Qadri very clearly explains to us, the wheel of the war economy always has to keep on moving in a way that burns excess value in the war economy. So this is just, again, the wheels of the two things happening. And we are talking about a system, an international system that is inherently sympathetic to that. However, that being said, let's say a very unconditional way of understanding international law is understanding that international legal discourse does not only happen in international courts, nor does it only happen among our colleagues and the mainstream international lawyers we see trotting around. It happens in the news, it happens in the streets. And whether we like it or not, the fact that the ICJ came and said plausible genocide opened up a lot of liberal spaces that claim their quote-unquote human rights and whatever. It misplaces itself in the public fora. And this is where the fight is. The fight is not in convincing people in the States, it's convincing people in the streets that this is happening because these liberal values are there. International law upholds its legitimacy by some abstract claim to justice, something. It's International Court of Justice. We're here to preserve international peace and security. That's what we teach you as students. As a first year going into international law module, I would be telling them, oh, there is this international system that is trying to pave the way. And of course, that's what would happen in most mainstream universities. So people engage with this system on the premises that it does offer this phantom of justice or hope. What we've seen in this past year is this utter failure that has led a lot who believe in the system. I know people who work in the ICRC, people who work there, to be like, are we really doing the right thing? Are we ourselves complicit? So this is what I call the insecurity of international, which is the fact that it sells itself as it represents itself under the veneer of justice. Meanwhile, internally, it's very insecure. It takes a little bit of study in international law and politics to see the real picture. However, that insecurity can be played on. And that is exactly what is happening now. People cannot uphold the claims that they are upholding. When UK politicians come and say, we are, as always, more civilized and nice and kind, and that's why we uphold our supremacy to the rest of the world, you can respond by saying that even in your own language, you're a savage. And that is the art of using international law in a strategic way. And that is what engaging with Palestine in the international legal fora has been shedding light on. So in short, this tells us that how we approach international legal practice must be understood differently. Alvarez in 1950s in the Anglo-Iranian oil case said that with the decolonization movement, now is the time to think of a new international law that reflects upon the experiences of people who were previously colonized. Indeed, the realpolitik and the world and everything else did not listen to him. How dare we have an international legal system that is logical? God forbid. Wal-'iyadhu billah. However, there is a justice-led reading of international law that promotes a harmonized understanding of the world, that looks at the real politics and understands that international peace and security can only be premised on equality, can only be premised when we enshrine an understanding of justice. This is what the critical international legal lawyers, Alakos Kenemi and the rest, actually overlook. This is what, when they look at the reading of people like Alvarez or people like Abi Saab and of people like Bejawi, they're like, oh, this is too indeterminate because it doesn't, we don't know what justice is. For colonization, the justice really looks very clear. And perhaps Palestine is an emblematic case to help us understand some of the main premises of justice on international legal fora that we could all agree on. Non-domination and non-exploitation sound like very good things that we could all agree on. And so a way forward is translating that justice-led reading of international law as a political project. The engagement with international law in an apolitical light is simply an absurd act, in my humble opinion. It doesn't make sense. This is politics, and it needs to be politicized. To understand it only in a positivist Western legal tradition is simply to facilitate the distortion of the world order that facilitates that tension that I just described. So to understand what we act in as political inherently and to partake in that in a justice-led reading is the only way to escape the dichotomy explained by Nimr so eloquently. And heading on to the next part, which also feeds on a similar reading of international law. What we're looking at...
My dear Shahab,
Sorry.
I am conscious that our speakers actually need to leave at this time. So I'm just going to say to both Daniel and Irene, thank you so much for joining us. As usual, we've gone overtime on this issue, particularly because of its importance and its significance to us as a community and to you as a whole, to all of us as a whole. I don't want to stop you, though, from continuing to go. I just want to ensure that our online speakers are able to now leave the audience or leave us should they need to, and to thank you both for your contributions tonight. Obviously, next time I host a talk with all of you involved, I'll ensure that I leave at least 2.5 to 3 hours for the discussion in light of what needs to be said. But thank you so much for joining us.
Thank you very much.
Thank you. Sorry to leave.
If there are any burning questions in the audience, but if there are, send me a message. I'll make sure the speakers get them on your behalf. I'm MK128 at SOAS. And if you want to continue, Shahad.
So as fast as possible. So the main issue that we have with the advisory opinion, again, it's an advisory opinion that came over 57 years after the occupation. And the problem did not start in 67 and only talks about the West Bank and Gaza. And you're all very familiar with from the river to the sea. There are over 8 million Palestinians that are outside of Palestine who have an undisputable right of return to that land. And also there is an ample amount of evidence in relation to Israel's international duty to pay reparation, to repartition, and to allow these people to go back to their homes. That's an illegality that has been systematic and structural, that has been going on since 1948. So when we look at the illegalities committed by Israel, we cannot only limit ourselves to understanding that system. Furthermore, it is very clear that Israel is undertaking an apartheid system even within its borders. Furthermore, Israel takes Palestinian prisoners within its systems against international humanitarian law. There's many different ways of arguing why when we understand Palestinian self-determination as decolonization, we need to understand it in relation to the totality of the area as understood through the right of return. To obsess over statehood in a post-colonial context is simply a false thing to fall into, because at the end of the day, as we learned from most post-colonial states, statehood is not what offers people sovereignty. Statehood is not what offers people self-determination, but rather non-domination and non-exploitation. And that, again, through a reading of international law that guides that, we see that the economic duty, third state economic responsibility, again, expands towards the whole of Israel. The best way to do that is by starting with the question of what is the purpose of third state responsibility here? To protect the Palestinian people against irreparable damage, to stop a state from committing grave illegalities. I'll end the event on this point. What has happened in Gaza is what can only be described as a scar in humanity's consciousness. And this is something that none of us will kind of, a thought that will never leave us for the rest of our lives. The only way for this to have, is to make sense, is for it to have meaning. It's for this to be the point in time, not only for the start of accountability for Palestine, liberation for Palestine, but also hopefully a moment for global political organization towards the ideals that Palestine stands as emblematic for. Thank you.
Thank you very much, Shahed. I don't really think I could have said it better myself, and I think it's only fitting that I live in the words of a Palestinian in light of the event that we're holding tonight. I would only add that, yes, it's a moment of reckoning for the liberal international legal order, and one in which we hopefully can rise to the challenge in more ways than one as an international community. Mohammed Bajawi in 1974 envisaged a world where the General Assembly would play a much more important and significant role, not to go back to international institutions in light of everything we've said this evening, but it may be at least a start for the road that we hope to travel. Colleagues and friends at home and here, I think it's now 8 o'clock. Possibly you want to leave us rather than ask questions. Am I correct in the room? Are there any burning questions, or shall we call it a night?
I got a question.
Okay, are people happy to stay in the room? I think, yeah, you're happy?
How are you reading the room?
Yeah, I'm reading the room here. I'm also reading the room in the Zoom room, which has thank you so much for valiantly 19 participants dealing with the psychedelic lighting. I appreciate that. I don't know whether there's time perhaps for one question, and then we'll call it a night. Thank you.
Turn the chat on Zoom.
Yeah, I'm turning the chat on. Hang on a sec. I've turned the chat on now in the Zoom as well for the last 5 to 10 minutes of the discussion. Yes, your question.
So I was just wondering, practically, you advise us, lobby your MP, get in contact with them. Is there anything else, or to kind of, help the consciousness and this?
Well, aside from all the Palestine solidarity, but also the question is a person-by-person question, because it's based on what you know how to do. If you know the law, then volunteer and work with the law. There's a lot of need for people in every single space. If you know any other thing, I think really each and every different person can have a contribution, as long as it's, and also the most important thing, of course, is to educate oneself as you go ahead with it. But yeah, aside from organizing in the UK, there's already so much organization happening. So it's just like chipping into the existing organizations.
Great, but that was a relatively quick question and quite practical at that. So thank you. Steve, another question. Anyone else in the audience? And one with the gentleman with the green jumper. Person with the green jumper. I can't see anything from the Zoom chat at the moment, so allow all participants to chat. Tick, is that right or not? I think the tick means they can, or,
The actual chat emblem
The actual-
on that side.
Yeah.
right.
Here it is, no, she's.
No, but sorry, I can see the chat, you can't. But, there's nothing at the moment from the participants themselves.
There's Michelle, huh?
Perhaps we can have the question again.
Yeah. I mean, I can put the chat there if you want, but it's just me and the, yeah.
No, hello.
So yes, Steve.
In terms of mobilizing the law, and as things currently stand, strangely, it seems to me like it doesn't really matter that much whether the crimes that have been committed by the state of Israel and are continuing to be committed are characterized as only war crimes and crimes against humanity, and a bunch of other crimes like the ones you've enumerated, but have not crossed the threshold to genocide, as long as there's a threat, a risk of genocide. And then I wonder whether, if perversely, ironically, if there were to be a ceasefire and IDF air and ground operations were to be significantly reduced, and the siege was to be significantly lifted, and people were to argue, well, there was a risk, but it hasn't come to pass, then you would be stuck in a situation where you would have only all the other legal mechanisms available, but not that particular mechanism. How, if that were to be the situation, if you were to lose those allies, as it were, who are basing their activities on the risk rather than the already committed reality, how problematic would that be? Does it really matter? As long as you have crimes against humanity, war crimes, et cetera, to use? Or is it so important to the campaigning, and you talked about people in the streets and all of that, that it would be a major blow?
I'll go really quickly, but like feel free to not answer or whatever. But yeah, I mean, I'm just really interested in this idea of like strategic or tactical intervention, you know, like using the law, not out of any love for it, but just like using it because we need to. And like, I think in the UK, maybe like two ideas that maybe if you'd like to expand on them, like the first one being like unions, like non-compliance, can unions, you know, for example, the civil service, we saw the Rwanda challenge last year. We have a similar thing where, you know, unions are able to not comply, but, you know, to invoke BDS and rely on international law to kind of give them some kind of protection. And then the second one being, you know, there's 20 people in the UK right now who are in prison for, you know, shutting down factories that make F-35 components or make drones. How can we, as international lawyers, you know, be thinking about intervening in those criminal cases, giving them protection?
Thank you.
So yeah, so I'm not 100% sure I get you. However, if there was a ceasefire to come in today, first of all, we are looking at the possibility of Sylvain Tande becoming the president of the court, which will be hilarious. A person who lacks completely any legal capacity. But if the thing is, the genocide already happened. And
not everybody agrees with that. Evidently, the ICC hasn't concluded that it has been committed. Maybe they're just doing the low-hanging fruit and waiting for additional evidence that they think will convince the pretrial chamber judges. Or maybe they don't think it's happened.
well, the thing is, okay, so this is, again, the question of the litmus test and the question of whether or not we want to call things by their name and whose words matter. A genocide has happened, there is no denial. And whether they want to call it a genocide or not call it a genocide, nothing in international law says that it needs to be declared by a court to be called so. And hence, so forth, this word will not be not used strategically. It will remain to be used strategically because, again, if we study the history, every single book that you could read about the subject matter of what constitutes a genocide has already happened. The importance of the word, well, it's not. It's an illegal occupation. It's a colonization. What the genocide has done is simply to unveil the existing liberal aura of distorting reality, but it was already happening. It was already there. It was, and Israel has, Avi Schleim calls it mowing the lawn in Gaza. Every few years, it goes into Gaza, mows the lawn, and comes out until it commits the ultimate thing. The gravity of the crimes committed, and with an international legal decision on the illegality of the occupation as a whole, there's no stance on which Israel can stand now.
Because under all the other legal mechanisms, you might lose the Genocide Convention if the legal characterization doesn't agree with your characterization, which of course you're free to have.
Well, that will then be a battle on the legitimacy of international law. I don't know if that's worth it or not as a battle, or what we would win by it. But also, it's a very big test of whether or not international law will be deemed absurd or not, because the question of genocidal intent is clearly there. Genocidal acts is clearly there. And if they want to discuss the nitty-gritty details of positivism into the abyss of humanity, I think I'll give you this answer. One lesson we've learned, and this you could see very clearly spoken in the Tantura massacre documentary, truth will inevitably be out. And even though things now seem to be morally indirect, history will very clearly call this a genocide. This will stand the test of time, is at least what I could tell you. Whether or not we manage to win it tactically or strategically at the moment, it being called or whatnot, whoever doesn't call it has failed the test of time in their statements, because that's the rule of history as I understand it. And unions, councils, and so yeah, exactly. There are so many different ways you can go about it, and so many different things that people could do. Up until now, I know that unions have been mobilized in the UK. Councils, a lot of people are working on mobilizing councils, and that's why we need as many people working on that, as a, not just for Palestine again, but as a general political act of repoliticizing. As we saw with the universities, what Palestine has done is to repoliticize the campus, which is exactly what is required in an age of extreme inequality and climate crisis and everything. I don't have an answer to all the different things strategically that could be done, but in reality, it is whoever picks a pen and gets creative about it can do it. And for example, what Palestine Action have been doing is extremely creative. As an act of resistance against the status quo. And that's what we need to have an understanding of, a very broad comprehension of resistance. Resistance is any act that looks at the status quo and critically and tries to pick on its existing presumptions. And that, in this case, is very big, and that's what we expect everyone could engage creatively with that. And if anything, that will give people much needed purpose in our times of being lost around the world.
Thank you.